What happened in the early hours of this morning is the kind of moment that law professors will be assigning to their students for the next 50 years. While most of the country was asleep, a 3-judge panel of the D.C. Circuit Court of Appeals handed down a decision that did more than just deny one of Donald Trump's emergency motions. It took a sledgehammer to the core of his legal strategy, rejected the idea that a former president enjoys sweeping criminal immunity, and sent a very clear message about how the federal judiciary views his efforts to cling to power after losing the 2020 election. And they did it unanimously. Trump's lawyers went into this phase of litigation with one central theory: that presidents must have near total immunity from criminal prosecution for anything they do while in office, or else future presidents will be chilled from making hard decisions. They wanted the courts to draw a bright line. Presidents cannot be prosecuted for official acts, period. The appeals court's answer was just as bright and just as categorical: no. The panel, 3 judges, all signing on to a per curiam opinion by the court, didn't just disagree at the margins. They didn't say, well, maybe there are limited contexts in which some conduct is shielded. They went directly at the heart of the claim. A former president, they held, does not possess absolute immunity from criminal prosecution for actions taken while in office, particularly when those actions are alleged to be an attempt to overturn an election and remain in power despite losing. The opinion used a word that federal courts reserve for rare occasions: unprecedented, necessary $1. Trump's alleged efforts to stay in office after losing the 2020 election, the court wrote, were unprecedented in our nation's history. That word is not decoration. It is doing a lot of work. It signals that the judges did not see this as a close case or a complex, arcane dispute. They saw it as something outside the legitimate bounds of the presidency altogether, something no doctrine of executive immunity was ever meant to shield. To understand how big this is, you have to zoom out. In every major modern presidential scandal, Watergate, Iran-Contra, the Clinton impeachment, the story followed a familiar pattern. Presidents pushed the edges of law and power. Their subordinates were prosecuted. They faced political consequences, investigations, resignations, even impeachment. But the system always pulled back from criminally trying a former president himself. Richard Nixon was pardoned before prosecutors could indict him. Ronald Reagan's top aides were charged. Reagan was not. Bill Clinton lost his law license and absorbed political damage, but he was never criminally prosecuted. For decades, there was an unwritten rule. When it came to presidents, accountability would be political, historical, reputational, but rarely criminal. This ruling is a formal legal rejection of that unwritten rule. The court laid out several key points that now hang over every criminal case involving Donald Trump. First, there is no such thing as absolute criminal immunity for a former president. Whatever functional protections exist while a president is in office, and those protections are real, they do not follow him into private life as a permanent shield. Second, not everything a president does is an official act of the presidency. When the allegations involve pressuring state officials to find votes, trying to strong-arm his own vice president into discarding lawful electoral votes, or using the machinery of government to subvert a certified election result, those are not the ordinary discharge of executive power. They are, at best, personal political operations. At worst, they are alleged crimes. Third, the panel was not persuaded that allowing this prosecution to go forward would somehow destroy the presidency. In plain terms, they said the greater danger to the constitutional order would be to announce that a president can commit crimes with impunity as long as he can plausibly claim he was acting in his official capacity. And fourth, by resolving the immunity question the way they did, they cleared a major procedural obstacle that had been slowing everything down. For Trump's legal team, delay is not just a tactic, it is the strategy. Every day the trial is pushed back is a day closer to an election in which he could reclaim power and potentially direct the Justice Department to simply walk away. Until this ruling, they had succeeded in freezing the calendar while the courts wrestled with immunity. That freeze is now melting. Under the Speedy Trial Act and the trial judge's prior scheduling orders, once the immunity issue is resolved at the appellate level, the clock starts ticking again. There is a statutory expectation that a criminal trial will begin within a defined window, roughly 70 days, subject to specific exclusions once these threshold questions are answered. That doesn't guarantee a trial on any particular date. Trump can still ask the full D.C. Circuit to rehear the case en banc. He can still file an emergency application to the Supreme Court. But here is where the political drama collides with the institutional behavior of the court. So far, the Supreme Court has been conspicuously quiet. No emergency stay. No immediate signal that at least 4 justices are ready to jump in and hear the case on a rocket docket. No sign that the conservative supermajority, including 3 justices Trump himself appointed, is prepared to erect a broad new shield of criminal immunity around the presidency. That silence is deafening inside Trump's legal operation. They built their playbook around 2 assumptions: that lower courts would be cautious and that the Supreme Court would feel compelled to protect the office by stepping in. Instead, they are now dealing with a unanimous panel decision that shredded their core arguments and a high court that, at least for the moment, appears unwilling to rescue them. Unanimity matters here. A 2-1 split decision with a strong dissent might have given the Supreme Court more room to say, this is a close question. We need to resolve it. A per curiam. 3-0 opinion, especially one that grounds itself in basic constitutional structure and history, sends a different message. This is not close. And that message doesn't just hit the D.C. election interference case. The logic of this ruling radiates outward into every other criminal matter involving Trump. The classified documents case in Florida, the racketeering and election interference charges in Georgia. Any attempt to argue that the presidency cloaks him in blanket immunity now runs straight into this appellate precedent. If the Supreme Court ultimately declines to disturb that precedent, the consequences are stark. It means that for the first time in American history, a former president faces multiple criminal trials in multiple jurisdictions without the artificial barrier of an invented absolute immunity doctrine. The political system is only beginning to absorb what that really means. Inside the Republican Party, you can already see the fractures. Hardcore MAGA loyalists interpret every ruling against Trump as proof of a witch hunt. More traditional Republicans, especially those in swing states, see something different. A rising probability that the party's nominee in a presidential election cycle could be a convicted felon under active sentencing supervision, tied up in appeals, and politically toxic in the suburbs they need to win. Public polling has consistently shown that a significant share of Republican voters, not a majority, but a meaningful minority, say they would rethink their support if Trump is actually convicted. In a polarized electorate, a 25–30% defection rate inside the base is catastrophic in a general election. At the same time, financiers, foreign governments, and adversaries abroad are watching the legal process with cold eyes. Allies in Europe and Asia are asking a question that would have been unthinkable a decade ago. Can the United States still be counted on as a stable, predictable democracy when a former president stands accused of trying to overturn an election and now faces the serious prospect of criminal conviction? Adversaries see something else, an opportunity. A country distracted by internal legal and political warfare. A commander-in-chief, whoever it is, constrained by domestic turmoil when making decisions about Ukraine, Taiwan, NATO, and the global economy. But beneath the politics and geopolitics lies the core constitutional issue that this appeals court decision forces into the open. Is the presidency an office under law, or is it a temporary throne? Trump's arguments, taken seriously, implied the latter. If a president can never be criminally prosecuted for anything he does in office that he labels official, then the law stops at the Oval Office door. Under that vision, a president could order the machinery of government turned against political opponents, pressure state officials to fabricate election results, or obstruct Congress's certification of electoral votes, and then stand beyond the reach of any criminal court once he leaves office. The panel's answer was simple and blunt. The Constitution does not create kings. For the country, the stakes are even higher. What is being tested in these cases is not just one former president's conduct. It is the proposition that the rule of law can reach all the way to the top, and that when it finally does, our institutions will have the stamina to follow through. The unanimous rejection of Trump's immunity claim is not the end of that test. It is the moment the real exam begins.